How's it going, everybody? I'm back. I am not an attorney and this is not legal advice. If you want legal advice, please contact an attorney. I'm making this video because I'm going to share my belief with everyone out there that anybody and everybody in the state of California can go ahead and disqualify a judge if they follow the proper procedures. The second reason why I'm making this video is because I know for a fact that everyone out there watching this video right now knows a family member or friend that spent $5,000 to $10,000 on a private attorney who always seemed to do nothing but complain about how crooked the judge was, how unfair the judge was, and yet at the same time they never filed a challenge for cause or a peremptory challenge or any kind of motion to disqualify the judge. Of course, I believe it's all about billable hours, but then again, what do I know? Okay? Now, before I get started, the 170.1 motion, okay, in my opinion, you have to state facts that kind of expose the judge doing things that he shouldn't be doing or she shouldn't be doing. So they're more apt to fight back in that situation. However, with the 170.6 motion, you just have to believe that the judge is not going to be fair, and that's it. No specific facts, you just have to believe something, and that's it. So that's the one I would go with. Now, both of these motions, you have to make an affidavit for both of them, under penalty of perjury, whatever the case may be. Okay, now 170.1A1 through number 8. So there's seven ways to disqualify a judge in the 170.1. The most commonly one used though is 170.1A6, which states a person aware of the facts might reasonably entertain a doubt that the judge would be able to be impartial. Okay, now we go to what's called the peremptory challenge to judge, which is governed by Civil Procedure Code 170.6. 170.6 states only requires the defendant to allege that the judge is prejudiced against the defendant or his or her attorney, so that the defendant cannot or believes that he or she cannot have a fair and impartial trial or hearing before the judge. If the motion is filed timely, the judge must disqualify himself or herself. Now, for it to be timely, there's 4 ways. Okay. Number 1. The master calendar exception, which means it applies if the case is sent to start trial from master calendar court. Okay. The second one is the 10-day, 5-day exception. If judge is known at least 10 days before the start of the hearing, the 170.6 challenge must be filed at least 5 days before the hearing starts. The third one is the all-purpose assignment exception is if a case is assigned to a judge for all purposes, then the 170.6 challenge must be filed within 10 days of notice of such an assignment. And the last one is ruling on the merits exception, which means a 170.6 challenge cannot be filed after a judge has made a ruling on the merits of the case. So as long as none of that happens, you're good to go and you can file a 170.6 motion. Okay? So keep this in mind, folks. The first one is called challenge for cause to judge. The second one is called the peremptory challenge to judge. Please do the research and verify what I'm saying, because I could be wrong. And if I am, go ahead and leave a message and explain how I'm wrong and what's the correct way of doing it. So please rate, comment, subscribe, favorite, spread the news, because too many people out there do not know that this is available to them. Godspeed.